President Trump has made true on his promise to deport illegal immigrants out of the United States. But what if I told you that cases involving Garcia, the man from Maryland, or other deportations may not always be about the individual, but about the process? This is the debate right now in the U.S. government, the debate between deporting immigrants and the question of due process. So what is due process? Does it apply to these immigration cases? And what exactly is the Supreme Court getting at in their decisions? We're joined by Dr. Adam Carrington, professor in the History and Political Science Department at Ashland University, to break down those questions and more. It's all coming up right here, right now. I'm Sam Chen, and this is Face the Issues. Good evening and welcome to Face the Issues. I'm Sam Chen. It's a promise that the President Trump said he would make good on during the campaign, stopping illegal immigration, deporting illegal immigrants back to their respective home countries, and he has been making good on that promise. And there's been a lot of controversy over the deportation of people to El Salvador, including Kilmar Abrego Garcia from Maryland. That's the current fight, as well as the detaining and deportation of various students for their involvements in protests and so forth, the canceling of immigration visas, questions about green cards, and so forth. But in law, this question centers on perhaps less about who these people are and more about this thing called due process. So what is due process? Does it have a role in these immigration hearings? Dr. Adam Carrington is associate professor of history and political science at Ashland University. He's the co-director of the Ashbrook Center, friend of our program. He's going to join us to break down these questions. Adam, welcome back to Face the Issues.
Thanks for having me back on. Glad to be talking with these things with you.
Yeah, thank you for joining us. And Adam, as usual, when we have you on, these are hot button political topics that come before the court. And as you said so articulately in the past, the court rarely, it shouldn't ever be looking at this as a political issue. And so we're taking a very legal constitutional look at this question. And like I said from the beginning, this was a campaign promise cracking down on illegal immigration. A lot of people voted for President Trump on this promise. This was something that President Biden was seen to be weak on, of not really securing the border, not really understanding that immigration issue. The Democratic Party seemed tone deaf about this throughout the campaign. And the case that kind of came up here was involving this group called MS-13. It's a South American gang. Some have labeled it a terrorist organization. And there is a deportation involving them. And the understanding here is that several of the deported class petitioned the court, and Judge James Boasberg put a hold on it. The president deported them anyway. And then we found out some, like Kilmar Abrego Garcia, were not actually part of the class that was meant to be deported. And so let me start with this. The president is rooting his authority to do this in the Alien Enemies Act of 1798. And so let's start there. What is the Alien Enemies Act of 1798, and what is the president's argument to applying it in this case?
Yeah, I'll say that I never thought that I would have contemporary applications for the Alien Enemies Act, just beyond teaching it historically. But it's part of what originally were the Alien and Sedition Acts, passed during the John Adams administration, signed into law by him. It's the Sedition Acts that are the most famous because they were seen to be an attempt to suppress free speech of political enemies and contributed to the downfall of the Adams administration, the election of Thomas Jefferson, and the first peaceful transfer of power under the American Constitution. But the Enemies Act, there was more than one, and it had to do with what they thought was an upcoming war with France that we were going to get into. And it was a means given to the president to, if there was a war or an invasion that was leading to a war, to give the president fairly broad discretionary power to remove those persons that were citizens or under the jurisdiction legally of the country that we were fighting with, so that they couldn't engage in espionage or other illegal activities to undermine our self-defense and to further the war effort of those that we might be fighting with.
I mean, and all of us, I mean, hopefully all of us viewers as well remember the Alien Sedition Act from history class, from school. Has this been applied since the historic background you just gave us?
Rarely, but yes, it's still, at least the Alien Enemies Act. There was another Alien Act and the Sedition Act, which have basically gone away. But the Alien Enemies Act still, even in the early 20th century, was asserted or used, but pretty rarely. And always before in the context of a declared war or actual military actions. That's one of the big debates about its use here, is it is restricted to either a declared war, which we obviously don't have, and then the debate that has been going on about how does one define what an invasion is, and the differences on that. And if I could just say from the text itself, it defines as an invasion or predatory incursion that is perpetrated, attempted, or threatened against the United States by any foreign nation or government. And I think that's the challenge for its inclusion here is it's not merely is there illegal immigration coming into the country, does it have serious policy or even other issues or threats? It is this really an attempt by a foreign government to send its own citizens or subjects into our territory for nefarious, even military-like ends? And I think that's the crux of the use of this text in the current context.
Let me step away from the MS-13 question and let's kind of put it back, 20, 25 years. If this, it wasn't, but if this were to be utilized, say, post 9/11, and it was used in the targeting, the deportation of, say, suspected members of Al-Qaeda, do you think there would have been justification for this? I mean, Al-Qaeda, this is also the challenge, right? I mean, we talk about statecraft. There are states that there's a very clear definition in international relations for what a state is, and Al-Qaeda is not one. Hamas is not one. Hezbollah is not a state. And yet we know them as bad actors. We know them as terrorist groups. Would this limit the ability of the United States to do this with, say, a group like Al-Qaeda?
I think that is a tougher question than what we're dealing with here, because the issue that we've never quite resolved with terrorist groups of the magnitude of Al-Qaeda and others was that we typically have the category of illegal activity by criminal groups or criminal persons and warlike activity by foreign nations. And Al-Qaeda and like groups were kind of in between.
Right.
They were fighting for political ends, making warlike actions, but were themselves not nation states in the way we've understood that for the last 400 years. So I think that there would have been a stronger argument to say that they were included under these kind of understandings because of their political warlike actions, as opposed to a gang members and a gang not undermining the bad things they do, but that tends to more traditionally fall under strictly criminal activity as opposed to warlike efforts.
Oh, it's okay. That's a great breakdown. Now, what was the court's ruling on this? I mean, there seemed to be debate, and we saw this. Stephen Miller, advisor to the president, said the court unanimously ruled with the White House on this. Others say, no, it was unanimous the other direction. There did seem to be a divide on the use of the Alien Enemy Act. Where did the court land on this?
Well, I think the thing that the court agreed on was that whatever the interpretation of the Alien Enemies Act, and I think some of this is just how much deference the president is supposed to get, as well as I think underneath, if they took this case on in a fuller form, they would have to answer the question about invasion or war. But that what they did agree on was that under the Alien Enemies Act, some sort of process that I think we'll get into later was due to the persons that are being deported. And in that sense, the White House didn't win in the sense that they could unilaterally do this. At the same time, wording in the original Supreme Court per curiam opinion did say that in however the lower courts decided this, very large deference should be given to the presidency. And this is where, again, immigration's a kind of interesting thing because it's on the border between domestic and foreign policy. And the president's powers by the court have traditionally been understood to be much broader with a lot more discretion in the foreign realm than the domestic realm. So parsing that out, I think the court said we want to give the presidency a lot of deference. It's not absolute deference. So that's where I think both sides could think as a preliminary matter that they had the court at least giving them some help in their respective arguments.
You hinted at this in that answer. What is the primary issue the court is concerned with in this case? And I mean, we're using Garcia as kind of the token here, but it's more than Garcia. It's a number of cases here. What is the Supreme Court's primary focus on these cases?
I think for them, it's the parsing out what, given the president's preeminence in foreign affairs, what due process is still required to limit the president's application of the law regarding immigration, and therefore balancing that there are legitimate policy objectives that, whether you agree or don't agree with them, the president can pursue on this matter of immigration, while still saying that he has to do so according to law and applying that law fairly to individuals. I think that's the essential point, is balancing those competing obligations to enforce the law.
I like the use of the term obligations. Adam, we're going to go to break. When we come back, let's break down that question of due process. So don't go away. We'll be right back.
Watch Lighthouse TV wherever you go. Available on Roku, Amazon Fire TV, and Apple TV. You can view our in-house studio productions on demand, or watch what's on the station right now with our 24/7 live stream. Search Lighthouse TV online on your streaming device, or go to our website for more information. Visit lighthousetv.org to stay connected. There you can find out what's currently on the air and coming up, how to watch in your area on cable, satellite, broadcast, or streaming devices. Watch past programs or our live stream. Follow us on social media and learn more about the station, our hosts, and our programming. Lighthouse TV, positively different.
Welcome back to Face the Issues. Adam, when we left off, you brought up the idea of due process, and you said kind of the idea that for the court here is there are certain policy objectives that an administration may pursue, regardless of whether we like or dislike those objectives. The question comes down to where, if and where due process plays in that. What are the rules that have to be followed in that? Let's pick up there. How should we understand due process? Let's just say, aside from this case for a moment, what is due process? When you teach your constitutional law class, how do you explain it to your students?
Sure, and I think that's a great place to start, because due process is a concept that comes into our Constitution through the Fifth Amendment and the 14th Amendments, but it's much older. And it's the idea that ultimately the laws that are passed by whatever our legislative branch is are abstractions, and they're kind of hypotheticals. They're saying, if X happens, then Y should be done. But that doesn't answer how that abstract hypothetical law would apply to a real situation, to real persons acting in real ways. And so the process that has historically been understood has been a judicial process by which the law is tested as to how it applies to individuals, with the idea that sometimes the government applies the law rightly in how it enforces the law against a particular person, sometimes it doesn't, and that the judicial process is meant to assess, is the government being held to what it is limited by in the laws that we have passed in our country? And so what that looks like can be different in different situations. But ultimately, it's a question of what is a process by which we can assess if the law is being fairly applied.
I think the common exam or understanding in popular culture, right? You said in the judicial sense, law and order, where maybe someone's guilty, but the prosecutor is colluding with the jury, and you see issues of due process. Are we looking at the form of that, just on a maybe not as dramatized of a setting?
Yes, and when I said it can look different in different elements, the way we most understand it is what you said, having a full trial with a jury and a judge and lawyers. But the courts have understood due process to not always take the exact same form, and that can vary based on who, it can based on what's at stake. But it means that in some sense, there is a way of contesting how the law is being applied by the executive branch, and a way of therefore saying this goes beyond the duties of the government, or this is within the rights of the individual. And again, that can look different in different contexts, but a trial would be one example. Other places or other persons, it might look a little different, but I think that's still the essence of it.
Yeah. Let's talk about Garcia and these others. Again, it's not just Garcia. We're talking about there was people, college students, who were detained, deported, had their student visas canceled for getting involved in protests and things like that. Was their due process violated? Where did the court come down on these cases?
Yeah, Garcia in particular, the argument was it had been violated. And I'll say no less a respected jurist on the political right than Scalia, back in 1993, said it is well established that the Fifth Amendment entitles aliens to due process of law in deportation proceedings. And again, they emphasize that might not look the same as it would for citizens, or it might not involve a full-on trial, but that the court affirmed in its recent quick decision about Garcia that some process, some ability to contest the accusations made by the government, that were the basis for his deportation, is in line. And I think with student visas and others, I think the ability for the students to contest whether the law was being followed in how they were being treated, whether this was in the discretion of the executive branch or whether it could be rebuttable in court. Really, the affirmation has been that this is something everyone has a right to in some shape or form. Not necessarily that they're going to win, but that they have a right to say something in front of a at least somewhat impartial adjudicator, immigration judge, a federal court judge, somebody, to say, this is how the law should have been applied, and I don't think the government did it right. They may lose, but that they should have the ability to at least make their case.
I want to pick up on that. Like you said, they may lose this case. What we're seeing in public right now is the Trump administration is making this claim that Garcia is an MS-13 member. There's a whole debate about whether they photoshopped the tattoo and all that stuff. And then you had the senator going down and visiting him and saying he's a great family man. And there's this huge debate about his character. Is that even at play in this case?
Well, I'd say his character as to whether he's a decent human being or not, while I would say important in the grand scheme of things, isn't necessarily here. Whether he's a gang member, yes, would be the question. But it would be the question that would then need to be brought in front of the court. So I guess the essential question is, the government made that assessment, although at one point it claimed it did do it based on administrative error. But even if it did believe that it was that he was a gang member, what the Supreme Court has said is that's something that he should have had a chance to rebut before an immigration judge at least. So before you can even get to those other questions of his character or what organizations he was or wasn't a part of. The idea is it shouldn't just be played out in public opinion. Some sort of neutral arbiter should be assessing that claim and whether the government was at least doing its due diligence to act in the way it did in relation to those claims.
So it could very well be that he gets returned and deported again.
Absolutely. This is not, sometimes we get into debates where the process is merely a pretext for the outcome that we want. We shouldn't fall into that here. It could be perfectly the case that he should and could be deported as long as the process is followed. And what it is the process is meant to protect the administration of justice. And sometimes the administration of justice is that someone is guilty or that someone shouldn't be here legally. And sometimes it's not. What all the court is asking for is that we allow that process to play out so that we can have a better chance at getting at an accurate application of the law and an accurate application of justice.
Adam, when Judge Boasberg held this deportation or held the deportation of these individuals going over to El Salvador and the administration ignored it, was this the same idea of the hold? I mean, we're hearing debates like, oh, he blocked their deportation. Was this actually a ruling on the deportation, or was this a temporary hold? And what should be made of that and the administration not complying?
Well, to take that first question, it was, as I understand it, meant to be temporary. It was saying we haven't allowed the proper process to play out. We need to do that. So it was not a determination in the long term of whether he should have been deported finally. It was just saying we haven't let the process play out. And, it's interesting because as much as, on one hand, the Trump administration was trying to play with the idea that they could just defy the court, they then tried to intervene and say that they didn't really. So it's not clear to what degree the Trump administration at least wants to claim that it's outwardly defying the courts and to what degree that it's following them. And that question of to what degree the other branches, if they have a different interpretation of the law or the Constitution, can contradict the court, is something we really haven't run into much recently, but is certainly a debate that has gone on in other parts of American history and gets to how we understand this constitutional separation of powers. So as much as this is a very specific case about specific people, as we've touched on, there are fundamental questions that touch on some of the biggest issues of how we understand our constitutional order that are being debated and being sort of publicly and in the courtroom litigated in these cases.
Last question. What, as a constitutional legal scholar, what concerns, if any, do you have if due process is ignored in cases like this? Granting the argument that Garcia may be deported again, he may not be this great human being that a lot of people want him to be. What is the risk of ignoring due process because this is for the argument this is a terrible person who should not be here anyway?
Yeah, it's that human beings are fallible. We don't always know perfectly. We don't always think objectively. And sometimes there can be really obvious cases where that wouldn't matter in the particular application of the law. But the whole reason we have due process, the whole reason we have a judicial power to a certain extent, is that human fallibility needs to be checked by a rigorous attempt to hold our government and ourselves to the rule of law. And I think if you don't allow the capacity to let the process play out and even let unpopular figures or disliked figures have their day to make their case, you risk the law becoming a pretext for our own prejudices or our own ignorances, and therefore you undermine the pursuit of justice that our Constitution's preamble says is one of the reasons we established the Constitution in the first place.
Great word to end on. Adam, thank you again for joining us. Don't go away. We'll be right back.
Face the Issues is produced and recorded in the studios of Lighthouse TV. Positively different. Watch Lighthouse TV wherever you go. Available on Roku, Amazon Fire TV, and Apple TV. You can view our in-house studio productions on demand, or watch what's on the station right now with our 24/7 live stream. Search Lighthouse TV online on your streaming device, or go to our website lighthousetv.org for more information. Lighthouse TV, positively different.
Welcome back to Face the Issues. Adam, thank you again for joining us and helping us break down this contentious issue and shedding light on the legal side of it. Adam, as we close out, we said this last time you were on, you are at your alma mater now, Ashland University, which is in Ohio, and you are originally from Ohio and a diehard Cincinnati Reds fan. I mean, so much so that I think you're the only friend of mine that in all these last several years has been still very proud to be a Reds fan, despite some trying times. But you're finally back in your home state. What is your outlook this year for the Cincinnati Reds?
And I'll say we're recording this close to the time of the selection of the new Pope, who I know I can at least meet with in suffering because he's a White Sox fan. So yes, the Reds have not been what I'd hoped the last few years, but with Terry Francona, who I think can get the best out of any team, he's shown that, and the young crop of talent, hope springs eternal. So we'll see. That's one of the great things about baseball is if you stay loyal, you're going to have some rough times, but I think that makes the good times all the more sweet. So, yes, maybe I'm a fool for sticking with them, but I think I'm the 4th to 5th generation Reds fan in my family. So those kind of traditions are. I don't want to be the one to break that tradition.
Yeah. I'm a Cleveland fan in the American League. I've been an Atlanta fan in the National League, but I became a Cleveland fan in the American League when Terry Francona was there revitalizing the then Indians, now Guardians, and so certainly have seen him do his magic. Adam, you mentioned you're a 5th generation Reds fan. I was going to ask you how you became a Reds fan. How has it run this long in your family?
Well, part of it's geography. My family has since the 1800s lived in southern Ohio. So that was always the closest connection. And I think that also just sports has always been something, we talk about them as entertainment. We talk about them as something that, it's fun to do. But baseball was called America's game in part because it really does bind generations together. It really does teach certain principles that I think are good for self-government. And so I'm a Reds fan because I enjoy the game, because of history, because of family, but also because I'm an American. And I think that we don't want to deny the role sports plays in building community and also building up civic virtues and how they can translate to our citizenship.
I love that answer. Adam, thank you so much for joining us, for all your insights, and best of luck to your Reds this year.
Thank you very much. Best of luck to your teams when they're not playing mine.
Fair enough. I want to thank Adam Carrington from Ashland University for joining us. Of course, I want to thank each of you for tuning in as well. Hope to see you again right back here next week. Until then, my name is Sam Chan. On behalf of all of us here at Face the Issues, thank you and good night.